Hello again, everybody. It's Scott Casper for Takedown Media. A very serious topic today, the Nike hot seat populated by our friend C.D. Mock, the former head coach of North Carolina. He joins us. C.D., thank you very much for taking the time. I know this is a pressing matter. It's an important issue. We're going to talk a little bit about unequal protection on college campuses around the country for men and women. We're going to talk about your firing. We're going to talk a little bit about your son, of course, his being unjustly accused of sexual assault. We're going to talk about kangaroo courts on college campuses. We're going to talk about what's right and what's wrong from a parent standpoint and from the knowledge that you have as a head coach or former head coach, knowing what you know. We've got a lot of ground to cover. CD, are you ready to step into the Nike hot seat?
You bet.
Coaching for over 20 years, you've seen it all. Well, March 2014, your son was accused of sexual assault by a classmate at the University of Tennessee, Chattanooga. Take us to that point, Coach. What happened?
It's pretty public at this point, and I'm certainly not going to go into a lot of details, but the bottom line is that he was pursuing a relationship with a young lady there, and they had a romantic occasion one evening, and a few months later she decided that it was not something consensual.
So she made an accusation that it was not consensual sex and took it to her university, and they decided to take her place or take her part and defend her position, wherein you and your family had to hire legal counsel to defend something that, based on your son's opinion, was incorrect. It was wrong. Your son, senior, and was basically kicked out of school, losing his place on the team, his position within the sport, his ability to continue as a coach. A black mark will forever be on his record because of this accusation by this young lady. Am I right?
Yeah, that's correct. And I want to be clear that there's really nothing about his actions that evening that my wife and I condone. These are two people who made some very, very bad choices and bad decisions on one evening. What my contention is that, and his as well, is that there are two people here that made some bad decisions. And the problem right now, as you just alluded to, is the school really doesn't have a whole lot of choice. My old school, UNC, actually is even worse than UTC when it comes to violating young men's right to due process. A lot of the schools have different ways of dealing with it and different policies, and pretty much the entire thing rests on the definition of consent. That's what all of these things rest on. And the quick history of this, as I've brought out in my blog over the last year, is that and I'll be brief, the government basically, and I'm going to give you the mock paraphrase here, the Department of Education through Title IX basically said to the colleges, look, there have been abuses with situations where women have been sexually assaulted, and there were situations where high-profile athletes who had assaulted young ladies, allegedly, it was swept under the rug, and it was. And we need to protect these young ladies, and we are going to hold you accountable, schools, universities, if you don't provide them with proper due process, proper defense, then we're going to investigate you, and possibly you could lose your federal funding. Schools like UNC, UTC losing their federal funding would literally put them out of business. So they created a panic situation, a quick hip jerk, shoot from the hip response to a problem rather than doing it through a process. They quickly put that out there, well-meaning, obviously, but that's created an environment now where schools are afraid to do anything but throw young men who are accused under a bus. They don't want to be investigated. Who would? They don't want to be put out of business. If you're a chancellor or a college president and there's an accusation on your campus, and the feminist groups and other groups that support this affirmative consent policy are going to make sure that any accuser, any alleged victim, makes a complaint. And when they do, it's possible for the schools to be investigated. And any investigation certainly makes it possible for them to be punished or to lose their federal funding, and they simply can't take that chance. So it basically has tied administrators' hands, and there are administrators out there who will, not publicly, but will acknowledge this. They don't like this. They don't want to be in this business of prosecuting young men or being in part of the judicial system. But the Department of Education has really given them no choice.
So a judge advocate from UTC held a hearing involving all parties. This is where we're at. You hired an attorney, your family did. His accuser was represented by a UTC attorney at no cost, which I find it, there's an imbalance right there. The judge advocate found your son not responsible, but was 2 weeks later, with no additional evidence or fact findings, the judge advocate reversed her decision. Now, this is where it gets a little, hazy for me. I'm not understanding why the decision was reversed, and it becomes painfully obvious that they are motivated to find guilt on the young man, or the one in this case that was accused. Is that the way it all took place?
Yeah, and I don't have factual knowledge of this yet, but my presumption here, and I think it's a pretty good, realistic assumption, is that these attorneys who are hired by the schools, their job is to protect the schools, and attorneys are a big part of the problem here for both sides. Defendants, young men who are accused, many of them can't afford these attorneys, because you're not, if you're going to defend yourself in something like this, 20 grand is nothing. I mean, that's nothing. And there's not a lot of people out there that can just throw out $20,000, $30,000, $40,000 to go through something like this. And those poor people have no options. But what happened, and I think it's pretty clear from the record, is that this judge advocate, her name was Joni Sampirek. She was an accounting professor at UTC in the first year. An
accounting professor.
Correct. She had been she had been to law school, but she was not practicing law. She never practiced law, but she was a school representative, and she oversaw the hearing. In fact, my son was afforded more due process by having this hearing than most schools allow. Most schools don't even have hearings. Most schools won't even allow the accused to face his accuser. We had some good things happen from a due process standpoint along those lines, but the right terminology, people want to say guilty or not guilty. The right terminology in a college process like this is responsible or not responsible. It was a long hearing. Both sides got to share their evidence or testimony or whatever, and she found us not responsible. And clearly, over the next week, the attorneys for UTC started to scramble and say, wait a minute, this could be a problem for us. What if she files a complaint? Department of Education is going to come in here and investigate us. We just can't take this chance. And somehow they convinced her to change her mind, because literally there was zero new evidence, no new explanation really, just a change of the verdict.
That is a strange situation indeed for that to happen, but it seems like she may have folded under some pressure. A state appeals court judge overturned that decision and basically said that she had no business reversing her decision in the first place. Is that correct?
Yeah, but to be clear, the next step in that process was for us to appeal to the chancellor of the school. And that's the process at UTC, and that's exactly what we did. And then the chancellor, the day before my son's final exams for the first semester, the day before that, he kicked him out of school. He basically said, I am affirming the judge advocate's decision. We subsequently found out that the chancellor was notified the day before that the alleged victim had filed a Title IX complaint against the school the day before that. So either there's a lot of things here that are incredibly coincidental, or there's a clear picture. In any event, yes, he got kicked out of school. We quickly got a stay from local courts to allow him to finish his final exams for that semester. And then we had to go back and get another stay to get him back into school, which was huge. We also wanted him back on the wrestling mat. That was a big part of this. But the school absolutely would not allow him to wrestle. They couldn't keep him from going back to school. It had something to do with education. When you pay for education, education is a right, but athletics is a privilege. And the judge was not able to force UTC to provide him with a privilege. So that was in UTC's hands, and they basically said, I argued, look, this is we're going to appeal this, and if we win, you're doing him irreparable harm. It's his fifth year. He can't go back and compete again. At least let him, through the appeal process, wrestle, and they refused.
So the Department of Education has really put colleges and universities in a position of having no real choice but then to take those that are accused, in this case a majority of them young men. And this is what's important to me, is that parents around the country need to know what their kids are facing, with the young men in the world of sport or just in the greater world of academia. What their young men are facing, it's really quite a slippery slope, isn't it?
Yeah, I mean, Scott, look, when my son first told my wife and I about this last summer in June 2014, I guess, or actually it was like March, April. I looked at it, I read all the information, I looked at her accusation, and after looking at it, I said, well, this is a he said, she said. His facts seemed to be pretty right. He had some witnesses. He had a pretty strong case that convinced me that nothing terribly inappropriate went on here with regard to sexual assault. Alcohol was involved. Alcohol is always involved in these things, it seems like. That's kind of the common denominator. But having said that, I was pretty comfortable that, all right, we're innocent until proven guilty, and I feel like the facts here are going to establish my son's innocence. We felt pretty strongly about that. Over the next few months, I found out that facts mean nothing, literally nothing. And people need to know this. And around August of last year, I wrote to many of the wrestling websites and periodicals. I had a personal face-to-face conversation with one of the young men at Flow Wrestling, begging him to get the word out on this subject, because young men have no idea, parents have no idea what's going on college campuses today and how much their sons are in harm's way. And it doesn't hit you until it happens. That's the problem. So I sent a letter to Intermat, I sent a letter to USA Wrestling on the forum, asked them to put it on the forum, just to warn young men, just to warn them that, and look, this is difficult for me. I don't condone sexual activity. I would prefer that my son and all the guys out there abstain until they're married. But I'm also not an idiot. I mean, these things go on, and better to know and be educated. And that was my intent. And they just ignored me. They just completely ignored me, like they had no interest in it whatsoever. And it really frustrated me. But it's a big problem, and unfortunately most people don't know about it until they know someone who is caught in this. And the other thing I want to say is just that there are hundreds of people out there in the same situation that we were in. I get calls or emails from mostly mothers
Really?
every other week saying, my son is caught in the same thing, we've read your blog, we don't know what to do, we can't afford an attorney, and we're just afraid to come out because my son's name will be scarred forever. And so they have no choice but to walk away. If you can't afford an attorney, you really have no options. and they're not cheap. Attorneys are very expensive, and this is a much bigger problem than most people realize. And that's one of the reasons I was happy to come on and talk with you, because it just, more people know what's going on. Number one, they can protect their son. Number two, maybe be a part of the solution.
What is the Second Amendment as you know it? The Second Amendment to our Constitution?
Yeah, I messed that up on my first blog. Yeah, apparently, Second Amendment, I think, is right to bear arms. I went back and
I just want to make sure.
I went back and fixed it, but I'm a little late. Like I said, I'm not an idiot, but I'm not the sharpest tool out there either.
All right, so we have a right under the Constitution of the United States of America to free speech. We also have the right to have our own political opinions, surely opinions that matter to our family and to what's right. And one of those, of course, obviously upset your then employer, UNC, and you did a public blog talking about the dangers that young people are facing. They apparently had a problem with that, and they dismissed you from your duties and have done really nothing to help you or your family. I guess I'm rather disappointed. Not guess. I know I'm disappointed in North Carolina. I think I'm more disappointed, Coach, that issues like this, these, if in fact they are criminal matters, should be handled by criminal courts. Why is law enforcement not involved in this?
Well, that's been one of the arguments of the feminists out there, and I don't know. I hate to use the word feminist, but I don't know what else to call them. There's a group of, on the internet, a lot of people call them feminazis. There is a group that this is their agenda. Their agenda is to protect women at all and any cost. They are not interested in protecting the due process, period. They just want, on an accusation, young men to be determined guilty and removed. With the recent things like the UVA situation, Duke lacrosse, the young lady carrying the mattress up at Columbia, our case here, there more and more coming out realizing that sometimes there are false accusations, and we need to protect young men as well. But the problem with, as I understand it, I'm not an expert, but the problem with just having this done by law enforcement is that many women complain, as did my son's accuser. She was asked, why did you not go to the police? She said, I didn't think they'd believe me, and I didn't want to answer all the questions they were going to ask me. And that sums it up. I mean, a lot of women don't want to go to the police because they know the police's job or a DA's job is going to be to try to determine exactly what happened and put them through a series of rough questions. And they just don't want to experience that, which is understandable, particularly somebody that's really been raped or sexually assaulted. But that's the rub. That's what they use to describe why they want the schools to handle this. And obviously, if you're a proponent of this whole idea, the schools are a better place to have this handled, because the school determines the young man, the accused, guilty immediately. My son was kicked off the wrestling team immediately upon the accusation. No investigation, no nothing. That's what's done. Now, they can't kick him out of school yet. They got to have a hearing. But that is the way this is done. It is literally a violation of the Constitution. And finally, judges are stepping up and saying, whoa, no, you can't do that. You can't operate outside the Constitution of the United States. So that's encouraging. But I agree with you. I believe this should be handled by law enforcement. It isn't a perfect solution. There are problems with that. But there's no question to me that it is a better solution than the one they have right now. Yes, and what people need to understand is that the crux of this is consent. And what young men need to understand is that, and this blows people away, but young men need to understand that affirmative consent, as it stands right now, as it's law in California and New York, it means that a female, and I'm going to say female because let's be realistic, men don't get raped. A female must say verbally yes through every stage and progression in any sexual encounter. That's the definition that's being used right now in 2 states and maybe more, and being pushed by Congress people right now all over the country. They want this even sterner. So it's a process where, if you can imagine, two people are together, they're attracted to one another, they're dating, whatever, and they're kissing. Well, first of all, to kiss, you're supposed to ask. A young man reaches over and kisses a young lady without getting permission. A verbal yes, not a head nod, a verbal yes. That is sexual assault. He can be kicked out of school. That's happened. That has happened right now around the country. So, then it progresses. They're kissing, and she's responding and seems to be very much into it. Whatever the next step is, he needs to stop and get another verbal yes. That's affirmative consent as it's being defined. So young men need to understand this. A woman who is physically responding to you by her actions is meaningless. It doesn't mean anything. It is not a defense, and you will be prosecuted if you proceed. Again, you don't get in trouble if you just abstain and wait until you're married. But beyond that, know what's going on.
So let's go back to the 9th of August. Corey Mock wins his state appeals in court. So it says on your blog, basically, the Tennessee State Court judge, and I'm reading from your blog, the Honorable Chancellor McCoy ruled that the original finding back in the first hearing at UTC in June of 2014 by the Judge Advocate Joni Simparek found that Corey, not responsible, should not have ever been changed. So I'm going to ask you about this. Personally, for you, the judge's strong opinion of some 24 pages basically says what you've been saying in your blog since day one. So I don't understand how you can reverse a 24-page decision. How would you write 24 pages of supporting your idea and your decision and then reverse it with no additional... That has me scratching my head since the first time I read it, with no additional evidence, no more testimony. 24 pages, CD.
You're talking about the first hearing that was reversed?
Yeah, I'm going off your blog on the 9th. Yeah, it says, and this is, I'm quoting you, for me personally, the judge's very strong opinion of 24 pages basically says what I've been saying in my blog since day one. And I just find it very interesting that it's taken us to get to this point to prove out in a state court of appeals that, the first opinion was right. They didn't have the right to go back and change that opinion based on no further input from either side, at least from your side or your family's side. It just doesn't seem right. And what we're seeing here is this so-called kangaroo court, and I think people are really calling it that. They're not set up to handle this situation. That's why I think my point really is, and I think my view really is, I feel anyway, that it should be in a legal court system being dealt with by professionals that deal with these type of accusations and these type of situations on a daily basis. I don't think our universities should be set up to police themselves, if only for a convenience, to satisfy, whether they are federally funded or not. Agree or disagree? Oh,
adamantly agree, and that's been my contention in my argument in my blog, which obviously UNC wasn't very happy about. And I know they got bombarded. I know UNC got bombarded. I've been told that. Emails, phone calls, all kinds of propaganda to try to get me out, because there's a lot of people out there that didn't like what I was saying. And a lot of those people are close to the chancellor and to some of the other administrators at UNC. And I knew I knew that I was playing with fire. I understood that, but I didn't feel that I had any choice. The fact of the matter is that once these decisions get outside of the school in appeal and go to the judicial system, many of them now are getting overturned. We've had 4 this summer already that have been overturned. So, look, I've been very critical throughout my career at UNC about the UNC Honor Code. The UNC Honor Code is very similar. I'm using this as an example because it's kind of similar. If a young man is drinking alcohol and gets into a squabble, a fight or something on Franklin Street in Chapel Hill, and he's a student at UNC, and he gets arrested, or the police are involved, that not only is a civil issue, or could be a criminal issue in the town of Chapel Hill police, but it also then goes to the honor court and the honor system at UNC. And now you've got a group of young people, students, who are sitting around a table who are going to determine your future because you were drinking alcohol and fighting uptown. And I've been very vocal to the UNC Office of Student Affairs, as well as the Office of the Chancellor, about why is the educational institution in this business? I don't understand. It's an educational institution. Cheating, anything related to education, honor court should be involved. But to put young people, students, 18 to 20 to 21, 22 years old, who have exceedingly limited experience in life, judging other young men and women who have made some mistakes, to me is insane. And I've seen people kicked out of school. I've seen people, in my view, harshly dealt with in these honor court systems. And it's the same thing. Why are they in the judicial system? Obviously, sexual assault is a much more severe issue than just fighting or something like that, which goes on every day. But it's a problem. It's a problem that the educational system is involved in these things. They don't have the training. Right. They don't have the people. They don't have the experience. And I think you've hit the nail on the head, Scott. That's one of the big problems. But it's not really their fault that they're in this business, and that's the key. I'm very careful not to be too critical. I'm critical of the institutions because I think their leadership are cowards. That's my opinion. I think they're cowards. I think they are. Now, one might say, well, it's their livelihood. Well, nevertheless, we hold these people up as leaders, and I think they should stand for something. I think they should stand for honor and integrity, and to allow something to go on that's unfair, that's unfairly treating the students that are at your university, and you know this to be true, and to allow it to go on because you're afraid of what's going to happen with the government. At the very least, the leadership around the country in the educational institutions should be joining together and addressing this with the government. They should be telling them this isn't right, it isn't fair. But they're afraid. And is that a valid excuse? Well, I don't think it is. I'm not afraid to lose my job. That's, you have to be, leaders aren't supposed to be afraid. They're supposed to have courage. So that's my criticism of them. But the real culprit in this whole thing is the government. It's the Obama administration that sanctioned all of this. And granted, their intent was good, protect women. We all want to do that. I have a daughter. I have a wife. I want them protected. But this is not the way to do it. This is just creating a whole new class of victims.
All right. Our guest, C.D. Mock, this is not meant to be a contentious interview, but it is an eye-opener for me and hopefully for so many of you. And you said it moments ago, our leaders should stand for something. We've heard it said before, if they don't stand for something, they'll fall for anything. Well, Real Clear Politics, a website, Kathy Young, the author there, has reported recently about the U.S. Senate Education Committee hearing that focused on the need for colleges to take stronger action against sexual violence and on a pending bipartisan bill, the Campus Accountability and Safety Act, otherwise known as CASA, which would penalize schools for failing to do so. Is there a better way? A new House bill, the Safe Campus Act, introduced by Republicans Matt Salmon of Arizona, Pete Sessions, and Kay Granger of Texas, stresses a greater law enforcement role and more safeguards for the accused. So they are recognizing it, whether or not they have enough votes and support to to affect change remains to be seen, but they continue the conversation, and hopefully before more young people get hurt. And it's not just young men, it's those that are accused. And that's what we're talking about. You believe the system is rife with bias against accused students? You're right. It absolutely is. And that's what we're talking about. We need to change the system. And parents, you should be aware that your young people are going to school with little or no representation. Be prepared. C.D. Mock wasn't prepared, but he stood up and took notice when his son Corey was accused, knowing what happened wasn't necessarily in accordance with the way he was brought up, but he still stood up, as is joined by his wife and other family members, and fought the system. And at this point anyway, he's won. But has he truly won? And that's the greater question, because that black mark will be on his record between now and the end of time. It's always going to be there. And that's what's wrong with the whole system. Falsely accused, but permanently marked. C.D. Mock has been our guest. C.D., in closing, do you have a final statement or anything you'd like to say?
Yeah, call your congressman. Call your congressman, call your congresswoman, call them and tell them CASA violates the due process of accused young men. It's not the way to go, and we need to defeat that. And that's the best thing that you can do. And next to that, educate your children about this, because college campuses right now, your son is in harm's way. There's absolutely no question about it, and you can do a lot to prevent that by educating them.
We would like to see fair and equal treatment under the law of all of our students and student athletes, be they male or female. And accurate representation under the law is our ultimate goal. For C.D. Mock, I'm Scott Casper, thanking you for joining us. This is a serious issue, folks, and it's not going away, and we'll keep talking about it. We appreciate your kind attention to this very special and important interview.